Okay, let's move on to question number 2 from Denise R. in Huron Township. And Denise says, I own a home and I am selling it on a land contract. The buyer passed away, but her adult children want to purchase the home. Can I sell it to them instead? Denise in Huron Township. And I was talking to David before we got started here, telling him that I was excited for this question because I'm buying I own and end up buying a few properties with a land contract, and the seller is actually sort of elderly, and so that's just kind of been something that's been on my mind. What happens if he passes before we we finish out the term there? So anyway,
well, you know what?
Denise
You're such an important person. I'm going to answer your question first, and then you can repeat the other.
Okay.
The question is what?
What happens if the seller passes away before we finish the term of the contract?
Yeah. So first of all, just in general, should you be complying with the terms of the contract, and your seller was complying with the terms of the contract? You know, the provisions of the contract should basically pass along to the seller's heirs or to the seller's estate. So they will have to honor that contract. Usually there's a provision in the contract, provided that you have the right attorney, address and draft the document properly. It will say
you drafted it.
Right, okay. You drafted it. So there should be a provision there that says it, the provisions inure to the benefits of the assigns or to the heirs and beneficiaries of the estate. That's number one, okay? So if everybody's doing what they're supposed to and you need to get a deed from, let's say you pay off the loan, the land contract, but you still don't have the deed because you didn't collect it at the beginning of the transaction, then the personal representative of the estate will ultimately be the one who executes the deed for you, and once you pay them off. Here's the thing. It's a big concern because there's nothing worse than having a land contract purchaser chasing around the whole state for that person's signature, right? After they've paid thousands and thousands of dollars and fixed up a home and they made payments, there's nothing worse than having to locate the next responsible party and beg them for a deed. It's really very unsettling. So the best way to handle this, and I've seen that, by the way, you know, I've been on the chase many times for clients. The better way to do it, and that, by the way, that's because they weren't my clients in the beginning, because in the beginning, what we do is we have the seller agree to deposit the deed already executed, placed in an escrow account at the title company with instructions to the title company that basically say, hey, when they pay off, this can be released, the deed can be released, okay? So I have several cases in this past year where that has not happened because what we have is, again, sellers who didn't put the deed in escrow, sellers who can't be found, sellers who now refuse to let a buyer pay off because the property values that you know, in that area have gone up, and they think that they can benefit by keeping the property instead of completing their obligations under a contract. So it's really hard, okay? It's hard enough to buy a home on land contract. It's hard enough to sell a home on land contract. You have to trust both parties. So do both parties a favor and overcome one more threshold of trust and put that deed in escrow.
Okay.
That's the answer. What was the question?
So Denise's question.
Yeah, okay.
I'll just repeat it for those who are watching anyway. She owns a home, selling it on land contract. The buyer passed away, but her adult children want to purchase the home. Can she sell it to them instead?
This just came up, and I was sharing this with you earlier today, earlier before we went on for the recording, and the answer is technically no.
Okay.
The buyer has an equitable interest in the property. The buyer is deceased. If she did not in some way, shape, or form leave like a will or some type of instructions, the adult children will probably have to have the estate probated so that they can substitute themselves for purchase, their parent who is purchasing on the property. Now, between the parties, if there was never a filed memorandum of land contract, which is a notification to the world that there is this transaction, underlying transaction, between the parties, if that's not there, anybody can do anything. Technically, the seller could cancel it and say, yeah, okay, I'll work with you and I'll credit you whichever your mother paid or your father paid, and I'll work with you and you just pay it off. That sounds really easy, but sometimes there's documentation out there that shows who is the actual purchaser. And so once you go, let's say, to transfer this property to a title company for a sale at a later date, the interest of that parent could show up somehow. And the title company will not insure it until they know that it's been probated. So it kind of works like like a regular home sale with a mortgage, an underlying mortgage, and that the individual who passed just was the only one on the deed. But the difference is there's this equitable interest, not a legal interest. It still has to be probated if it's of record. I hope that didn't sound too confusing, but you just can't go and sell it to the kids.
Yeah, what it seems to me is it's just not going to be that smooth of a process.
Never is.
Never is. But there's hoops you got to jump through until the answer can be yes. Okay.
I like that. I'm going to use that.
Yep, there's hoops you got. That's it. That's everything. Pretty much everything in life is a yes.
Yes.
But there's hoops you got to jump through to get to that yes.
Right.
Great. Excuse me.
Good
All
life
right. Exactly. Yeah, my